Hello, and thank you for joining us for another micro seminar. My name is Jason Castillo, the Director of Legal Education with Attorney Credits. If this is one of the first micro seminars you've logged on for on YouTube or on another website like encyclopedia.com, with these micro seminars, think of it as almost like a video issue spotting for you. I can't cover all the issues you need to know in a 5 or 10 minute micro seminar, CLE micro seminar, but I can give you some good food for thought, some good points to keep in mind in your practice on issues you need to be aware of, whether that's the legal ethics of websites and email, all the way to today's topic. And let's just use that as a segue to delve right into what I prepared for you today. And this is keeping in with some of the blogs and new courses I've done. I just did a course not too long ago on legal malpractice, a topic I'm sure nobody loves to think about because who wants to get sued, especially by your clients? So now what I've constructed is I've basically surveyed all the literature out there provided on the internet. I've looked at a million different resources from private firms, from the ABA, from state bars, and I boiled it all down for you. And what I did is I came up with my top 8 list, top 8 routes to legal malpractice, what you really need to be aware of. With that, I'll throw one caveat on in there, and that's under my first heading I've listed for you, which is the technology trap. Now that might not get the most attorneys into trouble, but you definitely need to be more versed in your electronic issues, and that's everything from e-discovery to law firm websites. Because as we progress further and further into the digital age, attorneys are only going to be held to a higher and higher standard as the regulators basically catch on and are aware of what's going on in our online environment. So under the technology trap, I've listed for you law firm websites, communicating by email, metadata, storage and security of confidential information, and e-discovery and e-competence. These are 5 areas in the technology trap where you can land yourself into trouble and get yourself or your firm in trouble. Now, law firm websites, where that's problematic is that many websites try to solicit way too much information from prospective clients. This could possibly lead into disqualification if you were to somehow have an email submission form and get information from 2 separate parties on the same claim. Also, law firm websites may set up an unauthorized practice of law claim from your state bar, from a state bar you don't practice in. For example, if I'm a California attorney, every person in all 50 states can see my website. And how do they not know that I'm offering them legal services in New York? Even though I'm in California, I'm only licensed to practice in California. And there's a number of cases that go to disclaimers, what you can and can't have on your website. Bottom line, what it comes down to, make sure you're doing what your jurisdiction sets forth. Try to know what other jurisdictions want of you, but that's still not going to keep you out of hot water. A couple months ago, somebody from the State Bar at the Virginia office, from the Virginia State Bar, was sending attorneys in California cease and desist letters to take their websites down because to them it looked like they were offering their legal services inside Virginia. So definitely something you need to be aware of. Craft the appropriate disclaimer. Take a look at different websites. There's a few cases on the book as well. You can email me at jcastillo@attorneycredits.com. I'd be happy to pass those on to you. Communicating by email, that's another huge gaffe. Be aware of confidential client information. A couple years ago, there was 2 misdirected emails that almost happened back to back where attorneys on the East Coast meant to send information to somebody, co-counsel they were working with. They accidentally hit the wrong address button on their Yahoo Mail, and this confidential information was sent to a newspaper reporter, one of which just printed the email right in the paper. I think it was in the New York Times. So be very careful when sending emails that it's going to the right person and you're not putting confidential client information in the wrong hands. Metadata, that's huge as well. Invisible information embedded in electronic documents that can be used against you. You must know whether your state, it's ethical to mine the data or what you have to do to scrub the data, because there's actually both duties on senders and receivers of metadata. And that one split right down the middle, 50-50. The ABA straight out said, go feel free to mine whatever you want. Many states have taken the approach that this is sneaky and underhanded and unethical conduct. Storage and security of confidential information. Again, this is protecting your client confidences, whether it's in a thumb drive, a laptop, your cell phone. Everything in the sun is nowadays is an electronic device. It stores electronic information, much of which during the practice of law comes from clients. This is information we need to be protecting at all costs. Old computers, I mean, it's just numerous issues that need to be protected. And then lastly, under the e-discovery and e-competence under the technology trap. As the 2006 amendments to the Federal Rules of Evidence have ushered in, and many states around the country as well, I think over half at this point in time, electronically stored information, how to discover this information, you must be versed on this. So that's just my first technology trap. That's just the first heading under what can get you in trouble for malpractice. Now second, missed deadlines and calendaring issues. These still tend to get many attorneys in trouble. The point there is make sure to use technology. Use a software calendaring program with multiple points of entry so you're not just stuck doing it at one computer. The third main point that attorneys get in trouble is with stress and substance abuse. Did you know that nearly 60% of all malpractice and discipline cases involve some form of substance abuse? So that's managing your stress, taking a day off every here and then, taking the kids to the park, doing something so you don't get caught up in the all-consuming practice of law. Fourth, poor client communication and relations. We all know that one of the chief complaints by clients is that attorneys don't return phone calls. Well, now that there's text messages, emails, Facebook posts, we've even got to learn how to communicate on a number of different communication mediums. Client intake, that's the fifth point that I list. Now, the client intake is huge because that's where most malpractice can be alleviated in the initial client interview. Think to yourself, do I want to work with this person? Is this somebody that I can actually work with and not get pissed off and fire halfway through the trial? The sixth point you need to be aware of is avoiding conflicts of interest. Again, one main thing there is to keep a database on your conflict of interest for people and companies that you represent, because nowadays in the American workplace, companies and employees, executives come and go. And just because this person was at one company 3 months ago, maybe they switched companies, maybe they've had a corporate restructuring a few years down the line. So again, this is a place where technology can help you. Our second to last and seventh point is inadequate research and investigation. And what a lot of attorneys might be tempted to do in this bad economy is to practice outside their practice areas. Take a bankruptcy case, maybe take a family law course because you think you can handle it, but then you can't because you don't have the knowledge or skill that you need to competently represent the client. You must either get with somebody, a senior attorney who knows what they're doing, or you must bone up on it rather quickly. Again, be careful. That's how you're going to get into serious trouble. And then lastly, fee arrangement and client funds gets many attorneys into trouble. And just the point I want to put in place here is that before you think about suing that client for the last $500 that they owe you, keep in mind that suing your client is the number way to get countersued for malpractice yourself. So think about whether that couple hundred or $1,000 is worth having your name dragged through the mud and having a complaint filed with the state bar, and then eventually taken into the court of law and sued for malpractice. So again, I'm Jason Castillo, Director of Legal Education with Attorney Credits. I just wanted to leave you with these points. Again, the technology trap, missed deadlines and calendaring issues, poor client communications and relations, client intake, avoiding conflicts of interest, inadequate research and investigation, fee arrangements and client funds. These are what you need to be aware of when it comes to thinking about legal malpractice. Thank you.